Welcome, everybody. I'm Frank Trainer. I'm the chair of the Administrative Law Council and I'm here with Catherine Lee and Ann Wall. Thank you for joining us on this next installment of our guidelines for navigating the rulemaking process. Our board is in the process of the second round of periodic reviews. I'm sure many of you are, or maybe you just have some general rulemaking that you're going through and needs a little bit of guidance. So we thank you for joining this. If you have friends who are not attorneys who are going through this process, by all means, make sure they get invited because they are able to watch as well. And you can also be a non-lawyer and and join our section to in a limited capacity to get other materials and that sort of thing. I also, while I had everybody, wanted to point out that we have a joint CLE coming up with the public sector and government attorneys. It's on November 14th. It's also going to contain some rule review guidelines, actually by Barbara Jackson, who was an actual member of the Rules Review Commission at one point. There's also an hour of ethics in there if you're trying to get your ethics by the end of 2025. So Lasara's put a link to that in the chat if you're interested. Um, with that said, I'm going to turn it over to Ann and Catherine.
Hi, I'm Ann Wall, and I'm going to speak first. Um, by way of background, for those who don't know me, I wrote my first rule when I was in law school in about 1975 or six, dating myself, and have done rulemaking for the Department of Labor and most recently for the Department of the Secretary of State. Um, most of my rulemaking experience is with writing rules for brand new laws, often that nobody else in the country has had to do before. So we'll talk a little bit about the difference between writing new rules and amending rules and those kinds of things. We will not be talking today about the REINS Act. We will be doing a Rules of the Road webinar in January on the 9th, and we'll have Julie Ventillaroo then from OSBM and Jim Hawhey, the consultant who helped us write our fiscal notes for the three different sets of notary rules we did over the last 3 years. And they'll be talking about fiscal notes. If you have questions, please put them in the chat. And if it's an appropriate time, Frank will interrupt us. We're going to talk about the kinds of questions you need to think about and answer as you write a rule, regardless of whether it's an amendment or the kind of thing I'm most used to, which is writing brand new rules. We'll talk about a few differences between amendments and rules and give some specific writing tips. And then we're going to talk about something that's really important if you want your rules to actually get through RRC, and that's formatting tips. Um, and always when you're writing rules, remember the why. And the why is the United States and the North Carolina constitutions. You're writing rules to protect the constitutional rights of our citizens to rights to due process and equal protection, which boils down in rulemaking to the notice and opportunity to be heard, treating people the same in similar circumstances, and not being arbitrary or capricious. When you're writing rules, one of the things you need to think about is your audiences. And we're not going to talk about some of your audiences today. That's the public, the General Assembly, and the courts. We are going to talk a little bit as we go about your other audiences. The first one you're writing for, obviously, is your regulated community. The second is RRC and the attorneys who staff it. And in some respects, they're more important because you don't have a rule if you don't get it through RRC. But one we often don't think about when we're writing our rules is our staff. And we'll talk a little bit about the importance of thinking about them as you write rules as we go. You have to balance all these needs and you have to be clear for all of them. but RRC is always the first judge. The important thing about thinking about your staff as an audience when you're writing rules is that every time you have turnover, you lose some institutional memory. And rules provide a sort of fixed point for new staff and old staff, when you're no longer there to help them, to interpret and apply the law. When you're figuring out what to write, many times you're just told, hey, we need a rule about X. And that may be all. They may just assume you know what they're talking about. Even if you think you know, ask questions. I usually sit people down in a room together at the very beginning to make sure everybody's on the same sheet of music when they're writing rules, because often someone has said to me, we need a rule about X, but when I bring in their supervisor or somebody else who's an expert, they go, well, no, that's not quite what we meant. So if you do that up front, you may be able to head off some problems later on when you get to RRC. And one of the most important things to remember is that most of the people who ask you to write a rule don't have a clue about what that means and what you have to go through, unless they've been around state government and been through the process before. And so you may have to do more explaining than for some people than others. I was a high school newspaper editor. And so I think in terms of the journalism 5 W's when I'm writing a rule. All these questions, who, what, where, when, why, will not necessarily apply to every rule and every amendment. But asking those questions as you go can avert issues later on, because a lot of those 5 questions are the ones that pop up in technical corrections. And throughout my presentation, sometimes I'll refer to technical corrections as technical corrections, and sometimes, for the sake of the slides, I've called them TCRs, which is what other folks also call them. Most of what we're talking about in this presentation, and in, to some extent, all of our Rules of the Road webinar, is one of those things that we all have to pay attention to, which is making sure that we can get the rules through RRC. And the more work you put in up front, the easier it's and more likely you are to make it through at the end. We're going to talk about the 5W questions in terms of both your regulated community and your own agency and its staff. As those questions apply to your own agency and staff, some of them will not end up in rules, but they're things that somebody needs to be thinking about. With regard to the who question, you've got basically who's going to be doing it in your regulated community. Is it everybody in the community, or is it just some? And if just some, which ones? You need to be really clear so that people know if they're covered or not, or if there are ways that they can change what they're doing so they won't be covered. That clarity about who is covered is really important up front. Also, your decision makers. You know, are staff going to be making decisions based on these rules, or are the real decision makers going to be your board, commission, or agency head? With regard to the who, you have to think about, are there exceptions or exemptions? And one of the things I've found is that over time, agencies develop practices and policies and don't necessarily realize that they're not covered in their rules and that they may need to be. And people need to know if they're automatically exempt or accepted from a rule, or if they have to do something so that an exception will apply. The example in our rules is that charities do not have to register with us if they get less than about 50,000 in contributions and they don't pay their officers and that kind of thing. But they do have to file something with us to show that they qualify for the exemption. So that's the kind of thing you have to think about. Some of it will be clear in your law, but it may need rulemaking just to clarify. And then, are there triggers? You know, if somebody is developing land on a North Carolina lake, does this amount of land, the acreage, affect whether they may have to apply with extra stormwater rules? And here's an example from a technical correction, one of my favorites, that one of the staff attorneys wrote, and you can read it for yourself. And this applies when you actually use terms that are in the statute. You can't, basically, they won't let you get away with just using the terms in the statute. The next W is what? What does the regulated community have to do? or not do or are prohibited from doing. You have to be clear about that. If there's a possibility of criminal penalties, it's especially important that you be clear because the standards are obviously stricter when you're talking about potentially putting somebody in jail. Does your regulated community have any options or discretion? In environmental law, there used to be, I don't know, I haven't kept up, but there used to be a concept called best available technology. And that meant that the regulated community had some options. It was circumscribed. But if the community is going to have some options or able to exercise discretion in how they comply with your law and rules, think about whether you need to clarify the parameters, the boundaries of that discretion in your rule. Do they have to keep any records? And Lord knows it's not often they don't. But if they do, you need to be clear about whether they're just keeping the records for a day, a year, a month, or if you have a specific time period for which they must keep the records. One of the things about record keeping requirements is a lot of times your statute or rules will already have record keeping requirements. And it may be that you can just tweak the existing requirements in a small way without having to write a new rule about it. So always check that. Then do they have to report something related to their compliance with the rule to somebody? If so, to whom? It has to be specific. Very important is, does that report have to be signed? Who has to sign it? And does it have to be certified as true and correct, or notarized under penalty of perjury? For example, from my days at the Department of Labor, the EPA Form Rs under the Clean Air Act, where businesses report all the stuff they put into air, water, and soil. Those have to be individually signed, each form, by the plant manager of the plant that's been putting the stuff into the air, water, or soil. So think
Hey,
about,
Ann, can you hear me?
yes.
I don't think anybody can see your slides advancing. Are you advancing your
Uh,
slides?
oh, geez. Hold on a second. Let me go back. I apologize. Let me just run through them quickly. I've spoken about most of it, but the most important one for you probably is to read this technical correction at the bottom of this slide. And I apologize for that. Thanks for interrupting, Frank.
No problem.
So this is this technical correction is one you have to pay attention to. And I'm going to move forward now. Here we are. This is where I was. Be clear about what they have to report in and to whom, and who has to sign it, and whether there are any requirements for signing, like under penalty of perjury. Then think about your agency and what you're putting into the rule that's going to affect you all. Are you all going to have to keep records? Are you going to have to review filings? Are you going to have to approve something? Do inspections? Very important, are you going to have to exercise any discretion? And if so, by whom and how? What are the factors to consider? Not all of that will necessarily go into your rule, but some of it may or will have to. When you're talking about exercising discretion, your rule needs to specify who is going to exercise the discretion. Is it going to be the secretary or commissioner or your board or commission? When will they exercise that discretion? At what point in the process? How will they exercise it? And by that, I mean, what factors are they going to consider? On what basis will they exercise that discretion? The good old days when both statutes and rules said using the secretary's own judgment or something along those lines, that will not fly these days. Here is an example of a technical correction regarding exercise of discretion. And this is a very common kind of technical correction. I'll give you a second to read that. And then I'm going to give you an example rule. This is an example. We just went through 3 years of rulemaking related to notary in a brand new across the nation, Remote Notary Act. This is the rule that we wrote about how we are going to exercise discretion when we receive a request for a waiver of a rule. Obviously, you can't waive a statute unless the statute says you can. But basically what you're doing, and there are tons of these kinds of waiver rules scattered throughout the administrative code. So feel free to use anybody's as a model for what you need. But what you're thinking about is, what do you need from the requester of the waiver? What do you all want to consider? How will it affect you? If you grant the waiver, is it going to make you totally inconsistent and look arbitrary to everybody else? And those are the kinds of things that you need to think about with regard to waivers. One of the important things that I didn't put in the slide, but think about when you're doing a waiver rule and you're talking about who can request or initiate a waiver of a rule, you can put in that your agency can initiate a waiver. And the classic example of when that might happen is after a Hurricane Helene, when you may have a deadline in a rule and you want to do a waiver that applies to everybody in the counties covered by the governor's executive orders and disaster declarations. Write your waiver rule so that you can do that if you need to. The when question out of the W's is, when will your regulated community have to do whatever it is you're telling them? And how often? As needed will no longer fly. And check the style manual with regard to the when, with regard to dates and times and those kinds of things. You have to be thinking about how specific are you going to be with your dates and your requirements for when. For example, when you put annual in a rule, do you mean December 31st? Do you mean January 31st? Or do you mean 1 year from when they filed their last report? Very important, that's something that had slipped my mind until fairly recently, is when you're using a word in terms of the whens that begins with bi, by. Bi-monthly can either mean twice a month or every other month. So you may not want to use that word since it might confuse people, or you may want to clarify it by adding a little language. And then with regard to how long they have to keep records, you have to think about, when does the trigger start for them to keep records, and when does it end? When can they decide to destroy the records if they want to? Another thing about the when is, especially if you're allowing electronic filings of any kind, do you want to limit it to 5 p.m. or, since it's electronic and you're not going to be in the office to accept it, can you say 11:59 p.m.? Think about those things when you're thinking about the when in your rules. Here is an example from a technical correction that I liked. So think about it. The other when questions are with regard to your agency and the decision makers. When in the process will you have to do something, and how often? Very important. And your counsel, your legislative liaison, even your communications director may be able to help with this one. Some statutes have deadlines that have been interpreted by the courts to say, if you don't meet that deadline as an agency, that permit or license or whatever is granted. And so you need to be aware of that when you're building deadlines into the rules. And obviously, how long your agency has to keep something may depend on a specific requirement in a statute. Or it may be just you check with the archives and the functional schedules. Here's an example for another of the 5 W's, the when, technical correction. And I doubt that this was, in fact, the agency's intent. The where question is one that sometimes people don't think really applies to most rules, but you do have to think about, where is the community going to take the action? Is it going to be at just one office? Do they have more than one work location that it will apply at? Will it have to be done at more than one place? Um, will where they have to do it affect where they do it, affect which rules apply to them? In childcare licensure rules, the number of kids that are being kept in a home can change the home from being covered by childcare home rules to childcare center rules, and there are big differences. Also, where to file stuff. I mentioned this earlier. Are they going to be filing their reports or whatever records they're keeping in their own offices, or are they going to be having to send something to you? And then think about where your agency will take the actions, particularly if it's like a board or a commission and there may be hearings. There may be something you need to actually put into the rules about that. The why question is the one that you may think you've already answered, because back at the beginning, I said to ask people questions when they tell you to write the rule. But my experience has been more than once that as you are writing a rule, you start thinking, I'm not sure about that nuance. I'm not sure this is really what they meant to do when I put it into actual rulemaking language. And so you may have to get those questions answered midstream, and people may get irritated with you for asking them again, but it's really important. And most important is to remember that among the factors RRC can consider is whether the rule is reasonably necessary. There are different ways to prove that a rule is reasonably necessary, and it's not something that comes up all that often, although it seems to more recently to come up fairly often. The one example that I thought of was there was an agency that was questioned in a technical correction about whether a rule was necessary. And I think staff may have even been recommending an objection. And the agency came back and said, hey, look, we are getting lots and lots of questions about this. It's clear that our rules are not clear on this point, and the statute's not clear on this point, and we need a rule to answer the questions. That won't always work, but it's one way. And it's one of my favorite ways, because if you can eliminate calls, that gives your staff time to do other stuff. Here is an example from a technical correction request with regard to whether a rule is necessary. And this may have actually been from a recommendation for objection now that I think about it. I'll give you a little longer to read this one. Talking about amendments. It just so happens that in the technical corrections, one of the staff attorneys had actually put a definition of amendment. And we should have said at the beginning, Lacera, our bar staffer, will be sending all of you all a link to the recording of this presentation and also a copy of our PowerPoint after the presentation. And we welcome feedback on all of those things. I actually think this definition might have come from Black's Law Dictionary for the lawyers amongst us. But it is useful to think about it. People think I'm nuts sometimes, but when I start with an amendment and I'm told I need to amend an existing rule, the first thing I do is read the existing rule and read it very carefully. There are times when somebody has told me, amend this rule to do X, and when I go and read the rule, it really already says X. It's just they haven't looked at the rule closely in a long time, or somebody told them they couldn't do it. So start with the existing rule. And when you're thinking about amendments, there's a children's song that when I was writing this presentation that kept running through my mind, the farmer in the dell. There's a line in it that says, the cheese stands alone. Amendments never, ever stand alone. Never think about an amendment as being a standalone. And the reason is that RRC can always look at the whole rule and require changes to the whole rule. Also look at the existing rule that you're amending in terms of the style guide and the RRC preferences that have been expressed in objections and discussions and technical corrections. Go on and fix any issues that you see in the existing rule from the style guide. It's not a guarantee it will fly through, because as RRC members have recently been wont to say, they have no precedent. But it's always better to fix issues in one rulemaking than to have to go back and do another one. It's just a real time sink for us as agencies, and we're wasting taxpayers' dollars if we have to go back and fix it, and we could have done it the first time around. Fix other issues. When you look at the existing rule, are there other things you need to amend than the one you were asked for? For example, if it's an old rule and it's talking about paper filing, and you've already had the programming done to accept online filing, do you want to go on and amend the rule to cover that? For the actual amendment, think about, are you just doing a small tweak? You're just changing a word or adding some punctuation to make something clear. Are you adding a whole new paragraph? If so, look at how the rest of the rule is worded and see if there's a particular style to that rule, a way that things are worded so that you want to word the new paragraph so that it fits sort of in terms of linguistics with the existing rule. Do you have another rule you can use as a model, or does somebody else, like the one I showed you with our waiver rule? I think I started that one with somebody else's waiver rule when I was writing it. Very important when you're writing that rule and you're adding a new paragraph or you're amending a rule, and you're part of what you're doing is an incorporation by reference to a NIST standard related to IT. You got to do it a certain way. Read the APA on that. Read recent discussions, go back and watch the videos even about incorporation by reference. There have been a number of objections and recommendations for objections from staff attorneys recently with regard to how an incorporation by reference was done. Also look, and a lot of people will just add a new paragraph at the end of an existing rule. That may not be what you want to do. Think about your audiences. It may make more sense to your staff if the rule, instead of being the last paragraph, you renumber everything and make it the second one. There may be some sort of a chronological or logical sequence where your new paragraph needs to fit someplace other than the very bottom. And always, can you make it a short rule? Because remember, if you can make it a short, separate rule rather than amending the existing rule, you are avoiding RRC scrutiny of the existing rule. And because they have no precedent, the fact that you amended the rule in September and you're coming back to amend it the next July does not mean that something that was perfectly okay in the existing rule in September will not be judged to be unclear when you get to July. Now, talking about my expertise, writing rules from scratch. When you're dealing particularly with a brand new law, involve your subject matter experts early. Don't write unrealistic rules. In our notary rulemaking over the last 3 years, more than once a division director told the group, wait a minute, we don't do that now. We're not getting extra staff for this anytime soon. And we'd have to do extra programming and our programmers are already overwhelmed. Do we have to do that? Do we really need that? Be pragmatic. You have to take into account all of our limited resources when we're thinking about how to write the rules. And of course, you have a statutory mandate to not be unduly burdensome. I was a trial attorney for many years, and I tend to think when I'm doing administrative law in terms of enforcement. I think it's wise to think about enforcement when you're writing a new rule, especially one that's from scratch. Would you really actually enforce and discipline somebody for whatever it is that you're putting in the rule? Consider new technology. If you can take online filings, if they can file something directly in our notary thing, there's some stuff that the technology providers are actually going to be adding directly to our database. And of course, we had to work with IT to make sure everything was kosher to get it all in without us being insecure. If it's a really complex law or how your amendment will fit is complicated, consider just sitting down and doing some rudimentary flowcharts and process mapping. There are times when that really can help. Figure out if you can get help from other agencies. I needed some definitions, and I got definitional help from the banking commissions, one of their lawyers, and I got help from the general counsel from DMVA. for a definition of something related to the armed services. Most people are going to be willing to help you. Consider fees, and I'm going to have a couple of slides about that. If you're doing criminal record stuff, it's a whole nother world. If you're already doing it, then you're familiar. If you're not already doing it, don't just talk to the SBI, talk to some other agencies that are doing. There are a lot of quirks. Just because the General Assembly said for you to get FBI records does not mean the FBI is going to give them to the SBI to give to you. There's sometimes a disconnect. When you're writing rules from scratch for a brand new law, it can be a lot more challenging because there may be nobody in the country like our remote notary rules that's done it this particular way before. It can also be more rewarding, and it can be a lot more irritating to people because it takes more time and you ask a lot more questions. Why write short rules? I've already told you some of those, and most of you have heard the spiel from any of us who've been around a long time and dealt with Bobby and Joe, the first lawyers for the RRC, about the wonders of writing short rules. The first one is the one I've already talked about, that RRC can review all of a long rule. The second one is better compliance by your regulated community. It's easier. Remember that according to the national literacy folks, high percentages of Americans read at an 8th grade or less level. So writing short, simple rules helps them to be able to figure out what they have to do to comply with the rule. Short rules with individual titles make it easier to find something for them instead of having to read a whole rule where maybe the only one paragraph is what concerns them. Short rules are just easier to understand, easier to find, easier to comply with, and easier to enforce, which makes implementation by your staff more effective. And truthfully, I've talked to coordinators who said, I've tried to get my decision makers to let me write short rules, and they won't. Call on some of the experts around state government, and they'll do what they can to help you convince them and explain all these things. Fee rules, there are extra things you have to think about that sometimes people aren't aware of. GS 12-3.1 is in a weird place. It's in the statutory construction chapter. And what it does is require notice to Gov and consultation with GovOps in the General Assembly, but not always. One of the things you have to look at for that particular provision of law and your fees is that frequently when the General Assembly passes a budget, they basically pass a provision that says, well, that doesn't really apply right now. So you have to double check that. The provision in the APA 150B 19.5, it limits what you can charge fees for and says some of the things that you can charge fees for, like conferences, publications. A lot of people aren't aware of the E-Commerce Act provision in Chapter 68. It allows you to actually charge the credit card fees, convenience fees, and that kind of thing. So it's worth looking at. And finally, a technical correction that relates to one I hadn't thought of because most of my statutes haven't had it. But some of us have statutes that say things like, reset your fee every 5 years in compliance with this odd quirk of the Consumer Product Index. If you've got one of those, think about it. And it's possible that RRC staff will ask you about it. There is a dispute about whether RRC itself has the authority, but sometimes staff asks questions out of curiosity too. When you're writing a fee rule, consider what kind of currency you're going to accept. With regard to US dollars, staff asked me one time, why was I saying US dollars? Well, there are a lot of countries that have dollars as their currency. And if you don't want to have to deal with changing from one currency to another, you may want to make it clear so when the person walks in with a dinar, you don't have to deal with it. And also think about cryptocurrency is coming. What kinds of payment methods are you set up to accept? Some of us are set up to accept PayPal. Some of us aren't. There's a specific statute in the Uniform Commercial Code about how much you can charge when somebody bounces a check. And you have to have certain things in your rules and signs and stuff like that to be able to charge that fee. Here's an example of one of our long rules, and then I'm going to show you, I'll tell you what this one says so you don't have to read it all, but then I'm going to show you how we broke it up into short rules. So the first paragraph is about paying in US dollars and cents. who you make checks to, and three or four kinds of payment that we accepted. This is an old rule. The second one is about if you pay us online, how you can do that. And at that time, we weren't taking credit cards. Everything else in paragraph C is about non-sufficient funds checks. These are examples of some of the rules we wrote as short rules from that one. So we made it really clear we're only going to take U.S. money. Think about the sovereign citizen folk. The second one is about if you're going to pay us online. Then we have another one that's similar to this, for if you're going to walk in the front door, then we will take cash. Or if you're doing it by FedEx or UPS, what we will accept from you. And then the last one is the first of a series of rules about the $35 processing fee for insufficient funds fees. When you're writing rules, word choice matters. Go back and look at Catherine's presentation from the last Rules of the Road webinar about the style guide. Also look at the OAH and RRC rules. In particular, in the style guide, pay attention to chapters 2 and 15. They're about words and phrases. One of them actually has, don't use this word, use this phrase. And an easy way, I keep a sort of running list. I read the technical corrections every month. I at least skim them. And if there's something that I don't already have in my notes where they've said this word is unclear, I'll add it to my list. This is something that I've heard people complain about, but not often. Sometimes staff will suggest a way to reword something, or they will suggest a better, clearer word. Be grateful for that, but don't expect it. Don't write your rules expecting them to fix it later. That's not really their job, but they often are helpful. If you're a lawyer, Lord knows, don't use legalese. Most people, we did a survey recently with the School of Government of Notaries about what they want in the new manual that deals with all the new rules. And the number one thing probably was, please write it in plain English. We're not lawyers. And the final one, and I can't give much advice about that, is terms of art. Every profession, every business, whether it's general contractors or electrical contractors or environmental health specialists, they've all got terms of art. Sometimes it can be hard to get those through RRC. And there are people around who can give you suggestions, but it may involve you actually bringing in some people who can say, everybody in the profession knows what this means. It is not unclear. Whether that'll work, I can't tell you. There are 3 rules that every agency must have: a rule on how to ask for a declaratory ruling, a rule on how somebody can submit a petition for you to do a rulemaking, and a rule that we already talked about on waiving rules. I will tell you that our February Rules of the Road webinar is going to be on the first 2 of these mandatory rules. It's going to be about writing rules for declaratory ruling requests and for rulemaking petition requests. I can't remember. It's the first Friday in February, I think. Here is an example about of a technical correction, and I'm going to leave this one up for a second. Technical correction about what needs to be in a waiver rule, and this will be in the package that you get from Lacera. So you'll have this slide, and it's a really good guide for when you're writing a waiver rule. And finally, in talking about amendments, writing new rules, repealing rules, this technical correction is really good at showing the linkage between formatting and writing. You can't have one without the other if you expect to ever have the rule in effect. And I'm going to hand it off to Catherine now. If I can stop sharing.
All right. Thank you, Anne. That was an excellent presentation. Very helpful tips for all of us who are out there writing rules on a regular basis. I am going to pause for a moment so that my associate Ryan is able to share his screen. So Anne, I don't know if you need to stop sharing yours first before we can switch.
I'm trying to.
Yep. And while we're doing that, I just wanted to say a big thanks to all of you for watching today. It's your participation that helps make these meaningful. So if you have questions as we go through this, please feel free to type it into the chat. If we don't have time to get to it today before we have to adjourn, we'll certainly take the opportunity to get back to you later and help make sure you've got the resources you need on these types of questions. Also want to give a big thanks to my associate, Carrie Dugnan, who helped put together this PowerPoint presentation today. We're very grateful for all the work she put into to digesting this down into a more bite-sized pieces for you to review. So I'm going to talk to you about formatting rules. And as Anne mentioned earlier, this is really a continuation from the conversation we started last month with regard to the style guide that's published by the Rules Review Commission as a resource for rulemaking coordinators. This time, we're going to take more of a heavy look into the actual rules themselves that govern the manner in which rules need to be formatted. So on the next slide, we're going to take a look at the 4 parts of the rule, all of which are equally important to the Rules Review Commission and should be to us as well. So each rule is required to have an introductory statement immediately preceding the text of the rule. That statement is to contain the rule citation and the action proposed to be taken. Second part of the rule is the rule name and number. And then following that is the body, the actual text of the rule. At the end of the body of the rule, you'll find the history note, and we're going to break all 4 of these pieces down as we go through our slides today. Go to the next slide. All right. So generally, there are guidance in the rules promulgated by the Rules Review Commission and OAH about how formatting needs to be handled, and they're all set forth on this slide here. We're also going to take these piece by piece and walk through them in the next slides. The first issue here for paper specs, we can go to the next slide, please, has here all of the requirements that are set forth in this rule 26 NCA CO2 C0108. I'm sure all of you are intimately familiar with these if you've had to file rules before, but it's good to see them here in black and white as a reminder that these are in fact codified and will be a basis for the rejection of the rule if they don't meet these standards. On the next slide, you'll see a quote that Anne helped pull out from a recent request for technical corrections that the Rules Review staff provided. And so even though it's not specified in the rule itself, the Rules Review Commission would greatly prefer us to use the Times New Roman font. So all of you sans serif fans out there, resist that urge and try to just bite the bullet and use Times New Roman when you're putting together rules for the commission. All right, next slide, please. I did want to highlight this snippet that I pulled from the OAH website. There is a special section under the Rules Division entitled Information for Rulemaking Coordinators. If you are not familiar with this page right now, I strongly encourage you to take some time and peruse it carefully. There are fantastic resources available here. And in particular, under Agency Rule Template on the bottom left-hand side of this screen, you will find that the Rules Review Commission has made formatting so much easier for us. They have put together macros in Word, and you can download those macros from this website directly that have embedded into it all of the different formatting requirements. So you don't have to come up with all of these from scratch if you take advantage of these available templates. On this page, you'll also, and that's okay, yeah. On this page also, you'll see other feedback on examples on how rules can be used. And so there's just a whole wealth of information there that's really worth your time to review. So we're going to turn next to tabbing and marging settings. And yes, can we get the presentations from today? Absolutely. All of these are going to come out to you after today. Sarah will be glad to send both the recording and the PowerPoint slides to you. Thank you for that question. So moving on to the tabbing and margins, this also is set forth in rule. So tab settings have to be in increments of 0.5 inches. Margins have to be set off 1 inch margins from all sides of the text. The next piece we'll talk about is introductory statements. Every rule has to have an introductory statement, as we mentioned earlier. We've pulled this example here that Anne found from a recent request for technical corrections from staff, pointing out that if your introductory statement is not correct, it will get flagged and you will be asked to fix it. So even though it may not seem as important since it's not getting into the body of the text, it's important to the Rules Review Commission. So what I want to highlight for you on the next slide here about introductory statements, that page I showed you earlier from the OAH RRC website has all of these examples built onto it. But here are the different ways in which you can prepare an introductory statement depending on the type of rulemaking process that you're following and the type of action that you're proposing to take to the particular rule. And so these, I encourage you to read both these and the information that's on the next slide to see exactly how that should be worded to make sure it's compliant with the regulatory requirements. Okay. And those will be coming out to you in the slides after this presentation. All right, in the next slides, we're going to talk about getting into formatting the actual body of the rule. And for those out there, this is the meat. This is the meat and potatoes of what a rule is going to be conveying to your regulated public. How you go about formatting the body of the rule depends on what you're doing to that rule. So if you're going to be including new language, it's always underlined. If you're amending it, you're going to strike through existing language and underline the new text. If you're appealing the rule, when you provide it to the Rules Review Commission, you don't include anything. So don't do what some might, and that is just strike through all of the text that's in the rule and say we're repealing it. No, you don't include any text if you're going to be proposing repeal of the rule. It's important not to skip lines within the body of the rule, except for very limited circumstances when you're doing perhaps tables or illustrations. That's going to be a very, very narrow exception. So generally, no skipping lines within the body of the rule. And turn off your automatic numbering or lettering of paragraphs and lists. On the next slide, you'll see another quote we had recently from feedback from the Rules Review Commission. Do not send in a rule that has track changes turned on. That is not the proper way to format the body of a rule, to do the strike throughs and to do the underlines. The Rules Review Commission will tell you that those track changes can be very easily lost, and they won't accept it if you try to send it in that way. Okay, we can go to the next slide. So in this next portion, we're going to talk about the levels of text, and there's a number of rules promulgated by OAH that give good definition to how you tab off within the different levels of text here. So this is really just a cut and paste from the rule. And so you can go back and look at this at your leisure as you need to. On the next slide, you'll see the codification of the information that you just saw here. There is different standards within the rule. So if it was a rule adopted by the agency prior to July 1st of 2024, excuse me, 2004, you'll see that there used to be more ability to list out multiple levels of text within a rule. From July 1st of 2024 and later, that was narrowed down to 3 levels of text within the body of the rule. If you're getting into more granular detail than that, I think you need to think about Anne's presentation earlier about, is there maybe just too much in this rule that should be broken out into multiple rules or into different paragraphs to make it more easy for your regulated public to read it and digest it. We go on to the next slide, please. Again, this is another illustration of how the levels of text within a rule can be designated. So having this visual might help you when you're putting your rules into the proper format here as well. Okay. We talked a lot about lists in our last presentation. There's good information in the style guide about how to list items. Oftentimes with my work, for example, for occupational licensing boards, say you might have an application or a form that you're codifying the substance. And often the information that needs to be in the form can be listed out. You need to have at least 2 items to make it a list. So that's important to pay attention to. And then also the punctuation that you use for listing is important as well. Rules Review Commission will tell you their preference is that you use semicolons if it is an incomplete sentence within the list, full periods if it's a full sentence within the list. And you can review this particular rule that's been promulgated as well by OAH with regard to how they wish their rules to be formatted, the lists to be formatted. Okay, next slide, please. And there's the rule right there. So you have it here in your materials if you want to refer back to that as you're going about drafting your rule. Here's an illustration how you can see the manner in which lists may be formatted with the proper tabs is there as well. This is an example of a rule that's actually published by OAH on how you can see they've done their listing within subparagraph 3 of this particular rule. And notice here the use of the semicolons at the end of the sentence until it gets to the very last item on the list, and you have a full stop period. All right, next. All right, and then here's another example of a rule subdivided by paragraphs. Again, looking at the manner in which OAH has promulgated their own rules is going to be probably one of your best ways to see good examples of proper formatting here. So we've dropped this into the materials so you have it available as well. Here's more feedback that we received, well, not we, but that we pulled out from another request for technical corrections recently. Again, just putting to you what we talked about a few minutes ago, the manner in which punctuation needs to be handled for these particular lists within a rule. Okay. One tip we've also heard RRC provide to rulemaking coordinators is that exercise caution when you're writing your rules and paying attention to the title that's used for that rule. Titles can be very helpful guides to your regulated public to let them know what is being covered within the rule and to help orient your agency as well to where in your code the materials need to be included if you're amending existing rules. But it is also important to remember that when you write out the rule, do it as if the regulated public couldn't even see the title there. You don't want your regulated public to be relying on the title of the rule to figure out what the rule is about. So a good exercise might be just to cover up the title and then see if the rule standing alone by itself makes sense or whether more introductory or clarifying language needs to be added, perhaps particularly to the beginning of the rule. All right, tables and illustrations we're going to talk about for just a couple of minutes here because this is something that I frankly have not seen very much in my particular practice. And I tried to go pull some good examples of recent tables and illustrations from rules that have been promulgated and really couldn't find very much. These types of tables and illustrations really are going to be much more technical. I'm sure folks over at DEQ and other more science-oriented agencies come across this more often. But the biggest takeaway I want you to take from this presentation is that there is a rule available for you, so you can get some guidance on how tables and illustrations should be handled if you do choose to do them. But do it carefully because it's not particularly favored within the Rules Review Commission. Next slide. Do not use footnotes. Do not use appendices. Those are not appropriate formatting tools for you. If you need to include illustrations or examples for your regulated public to make your meaning more clear, that's okay. But when you do so, make sure that the illustration you provided really is just an example or a clarification, which, if not read, it doesn't change the meaning of the rule. The rule that the RRC has on use of illustrations or notes is set forth in 26 NCOC 02C 110. And that rule will tell you if you are going to use those types of illustrations or examples, you should designate them with the word note to precede that particular example within the body of the rule. All right, we're going to jump in here to history notes for just a couple of minutes. History notes are really important. It's an easy thing, I think, for agencies to skip through, but the formatting is important and the history is important. The Rules Review Commission will absolutely look at those every time a rule comes before them to understand the full history and context. How many times has this rule been amended before? Were there ever any objections to the rule presented at the RRC? To signal to them that there may be more context that's important for them to consider as they're reviewing through it for possible objections. The rules that are on this slide are the 3 that I'd recommend you read to make sure you're doing your history notes in the proper format. We go to the next slide, please. Okay, here's just a couple of examples. So you can see the typical format for it. History notes are always going to be italicized. They start on the second line below the body of the rule. So this is one place where you do skip a line before you start into history note. The first line will say history note with a colon, and then 2 tabs over, and it will one tab over to get to authority, and that's where you're going to cite your authority for the agency to promulgate the rule. So you're going to go back to your enabling statute and any other statute that gives the agency the authority to promulgate that rule, and make sure that's there. And that's really important. And it may be something where the agency has authority in multiple places throughout the statute to promulgate that rule. My recommendation to you is grab every single one of those statutes and include it. Don't rely on just one, because if your practice act is ever changed and that statute is revised, removed, then you don't have to scramble to try to find those additional authorities that also give you the right to keep that rule in your code. Be thorough when you're pulling all that together. After your history note, you are going to get into the effective date of the original adoption of the rule. You'll see the abbreviation EFF period, and then that'll be followed by the date on which the rule first became effective. And those subsequent lines, you're going to see any amended effective dates, include any temporary rule history, or repeal dates would be at the very end of the rule if it were ever repealed. Okay. When you're putting your rules together and sending it over to rules review for publication in the register, you will need to give a projected effective date of the rule. And what I would encourage you to do is go through the publication schedule, work through that timeline to figure out when is the earliest date that this rule may be effective. It's typically the first month following the final RRC review of the rule. You can ask for a later date. It doesn't have to be the first month following whatever you anticipate that RRC review to take place, but it can't be earlier than that. So work through that timeline and come up with the date that you think is going to be closest to when it will actually come into your code. For temporary rules, it will be the 6th day following the RRC's review of the rule. So you can just work your way forward with that. All right, next slide. Wanted to share with you some of the ways in which statutes, rules, regulations are to be abbreviated within the rule. There is a rule promulgated by OAH that provides citations generally are to follow the Blue Book format, but there are certain exceptions to that. And those exceptions are citations to the general statutes of North Carolina, session laws of North Carolina, executive orders issued by the governor of North Carolina, North Carolina Administrative Code, and the North Carolina Register. So take a look at Rule 26 NCAC 02C 0109 for that, because that particular rule will show you exactly how those accepted citations are to be formatted within rules that you put forth. Okay, next slide. Okay, this is just a quick slide because I did want to highlight for you that the way you format a rule after it is published in the register is different than how you would format it and send it to RRC before publication in the register. So if you get a request back for technical corrections, just pay attention to the rules that are on this slide. It will show you exactly how additional changes after publication need to be highlighted, bracketed, underlined, struck through. That's important. There are important distinctions so that you understand the difference between the two different formatting techniques there. All right, next slide. Okay, just a couple of quick slides here on guidance for line spacing and bold print. Really, the only time you need to be bolding text within a rule is when it is the chapter, subchapter, and section names of the rule. You skip one line between your introductory statement and each chapter, subchapter, and section name, and you skip one line before the rule citation and the name line. I put a little snip here in the corner of this slide so you can see how that all caps text and bolding looks when you're starting with a rule that is at the very beginning of the section or chapter of your code. And you can see how the lines are skipped there as well. Okay. Again, some tips here on using bold text or capitalization. We've talked about the bold text. We talked about this also last time in the style guide. This is the time that you should be capitalizing particular words within your rules. Don't go crazy capitalizing stuff unless you really have clear authority to do it according to the style guide. Okay. Again, more feedback here about when capitalization is appropriate. If you're using the specific rule within your text, it's fine to capitalize it. If you're just generally referring to rules of the chapter, don't capitalize it. Capitalization for United States or state when it's referring to North Carolina is appropriate, or when you're referring to specific positions, you can capitalize that as well. We talked about this last time, so I won't dwell on it again, particularly since we're a few minutes after 1 o'clock now. But here's some guidance with regard to how to put text into your rule related to either numbers or money. So you can find that in your style guide or in the rules themselves as well. And then just pay attention to your punctuation. This is an easy thing for you to get tripped up on with technical corrections. What's going to be most important is whether you're using complete sentences or incomplete sentences, and just pay attention to that as well. And this is one of the last slides we've got for you, just a reminder about agency contact rules, a little unrelated to formatting, but it's still an important one to remember. There is a particular rule about how to put in your agency contact rule. So take a look at 26 NCAC 02C 0107. This tells you exactly what needs to be in your agency contact rule, and we've dropped an example here so you can see how another board was able to get it through the Rules Review Commission without any concerns. And my biggest takeaway for you, find that rules template we talked about earlier in the presentation. It will be your best friend as you're drafting rules, I promise you. And then if we can ever help you with a particular sticky question that comes up on formatting, our contact information is on the next slide for both Anne and myself. And you are welcome to contact us anytime. So thanks for sticking with me. I know I was talking really fast there toward the end of it, but we really appreciate your time and attention today. So thanks for joining us.
Thank you, guys.
We would appreciate any feedback and ideas for future Rules of the Road webinars. So you can send it to Frank, Catherine, or me. Thank you.